Hi, I'm Andy Powell. Welcome to the Purpose Project. All topics are fair game. I hope you enjoy. All right, Ryan Heath, welcome.
Thank you, Andy. This is fun.
If there's anything that we can't talk about, you should have already told me because we're going to get into it. So you are an attorney.
Yeah.
How long have you been an attorney?
Since 2020,
Okay. How long did you go to law school?
3 years.
Where'd you go?
I went to Regent University School of Law, which is on the East Coast. It's in Virginia Beach, Virginia.
Okay. And what have you been doing since you became an attorney?
Well, that's a bit of an interesting story. I initially, when I took the bar during the summer of 2020, during the COVID pandemic, I took the bar. I got recruited by a firm out of California to take over their Arizona office here. It's where I'm from, born and raised in Phoenix.
Oh,
And so I did that for a year, doing workers' compensation defense, civil litigation. I didn't really do a whole lot of actual courtroom work. It was basically me networking, playing a lot of golf, getting to know people. I have a background in sales. And so that was really what I was called in to do, was to build these relationships and build a firm. And then obviously COVID progressed, and really what kicked me over the edge was my sister being threatened with termination. She was a nurse at Phoenix Children's Hospital, and she was unvaccinated. And so I ended up helping her keep her. So that's sort of how I got into this. And since then, it was basically a day after that or 2 days after that Gavin Newsom said he was going to start sticking needles in kids' arms for a condition of going to school. And I told my wife, who was 7 months pregnant with our second baby at the time, that I was going to quit my job and start a nonprofit. And that's what I did.
and how's that going?
It's going well.
Good.
Yeah, I'm having a lot of fun with it.
Good, good. So what's the purpose of this nonprofit mainly?
So we are an anti-woke nonprofit. It's called the Gavel Project, and we help women, children especially, who are being targeted by ideological, let's call them ridiculous policies that schools put in place, that are put in place by workplaces, things like that.
Yeah.
And we help them get basically personal liability against the folks that are injuring them, so this stuff stops.
Okay. When the government tries to, or when the government does create some sort of a mandate, what is the legal foundation of that? How can they do that? What allows them to create a mandate in general?
So it's a broad question. We're talking about, let's say, for example, the vaccine mandate for kids in schools. They were claiming largely that the health policies, the inherent power of the police state, that being through the 10th Amendment of the United States Constitution, gives to the states the police power. And you as a state have the responsibility to look after the well-being of your citizenry. Unfortunately, in these cases, they were basically putting in place laws that conflicted with the constitutional rights of us citizens, which are superior to those of the states. And so there are a number of laws that are in place that protect individuals, like the First Amendment, for example, which is a very strong law in this area, especially with respect to the COVID-19 mask mandates, the vaccine mandates. You have a right to disagree with compelled orthodoxy from the government. That's explained very clearly in a number of Supreme Court cases. For example, West Virginia v. Barnett was a case out of West Virginia in the 1940s. During the throes of the World War II that was going on, obviously, and they passed a law, this was the school board in the state, that students had to stand for the Pledge of Allegiance. And there were a number of Jehovah's Witnesses in that case that actually protested. They were threatened with truancy, their parents were threatened with arrest. They filed a lawsuit, took it all the way to the Supreme Court, and the Supreme Court said very definitively that the government does not have the right to compel you to accept ideas as an individual. The First Amendment, protects that to the 10th degree. You can't be compelled to accept ideas concerning profound issues that relate to you as a person. They can't make you accept one point of view on any particular viewpoint or topic. And so those students protested. They took the case to the Supreme Court. The Supreme Court ruled in their favor. And they said, you don't have to stand for the flag. When someone looking at you, any reasonable person would understand that by, sitting down and protesting, you are refusing to accept the ideals of that symbol, the flag being, nationalism, patriotism, uniformity in that capacity. And so they said, that this is a fundamental right. It's the most important right that we have as citizens. And that's really the basis of all the lawsuits that we file, is the First Amendment.
Wow. Okay. Now, unfortunately, even though there is that ruling, that does protect us from government mandates and, let's say, school, because school is a part of the government as of now. But in the workplace, does it protect you from a job or a company making a rule in their own corporation that you have to do this or that?
Well, let's take, for example, the OSHA mandate, right? That was the big one that kind of threw everyone into a loop. And I would contend that because the government in that case actually compelled compelled companies to force their individual employees to take the vaccination, then it's actually a government mandate. It's not an employer mandate. Employment relationships are contractual in nature. It's strictly contractual. So you and your employer can negotiate whatever terms you want. But the problem, at least in Arizona, a lot of people don't seem to realize, is that even though we're an at-will state, and this is actually how I helped my sister keep her job, even though we're an at-will state, there's this wonderful case called ITT Tech v. DeMace, and it's from the early 2000s. And that was a Supreme Court of Arizona case, and it said that even though you're an at-will employee, you have implied, in fact, contractual terms that arise from the circumstances of your hiring. So my sister, for example, was a nurse, and when she was hired by Phoenix Children's Hospital, she no longer works there. She just left a few months ago.
Good for her.
Yeah, when she was hired, she had a enumerated list of vaccinations in the employee handbook that she had to take as a condition of attending or being an employee of the institution.
And the COVID vaccine wasn't a part of that list.
Obviously, because this was something that was new. And the hospital as well didn't retain the right to change the provisions of the contract, which is actually something you can do in your employee handbook. They didn't do that here. And so this case basically says, ITD Tech, anything when you're negotiating that is a detriment to the employer, it costs the employer something, it's a benefit to the employee. If you make a representation to the employee here in Arizona, and by the way, this isn't legal advice for anyone listening, just to throw that out there.
Yeah.
This is just general knowledge about the laws here. And anytime you represent something, let's say you don't have to have a written contract in Arizona for employment, which is a fundamental issue. But if you offer someone health insurance, for example, as like, you're going to come work for me, I'll pay for your health insurance. Arizona law holds that you can't unilaterally modify that employment contract without offering some sort of consideration and having it accepted in exchange. So in this situation, what PCH was effectively doing is they were saying the only way you get to keep your job is if you accept this additional term. And by the way, we're not going to give you anything in exchange for that risk that you're taking on as an employee.
And that didn't hold up because they didn't have the provision in their employee handbook that we're allowed to change the rules at any time, and you have to abide by that.
Correct. And had they done so, this argument wouldn't have worked.
Fascinating.
But it worked. We got a letter back the day after she was supposed to get terminated. And this organization that does $500 million a year in revenues conceded to a first-year attorney on a huge issue. So I was very blessed to be able to do that for my sister, and that gave me a big vote of confidence to be able to go out and stand up for kids, and that's what I've been doing ever since. I was really blessed in law school. I think I mentioned earlier I went to Regent University School of Law. Justice Samuel Alito was one of my professors. Okay. I actually was in D.C. in January of 2020 taking a class on constitutional interpretation from a Supreme Court justice.
Awesome.
So, this is, I believe I was born to do this. And,
excellent.
Yeah, God put me here for a reason.
Good, man. Good. Awesome. Well, let's get into what's going on with the election integrity stuff and Abe Hamedeh, because you're currently representing Abe Hamedeh?
Yeah, so Abe is a client of mine. I have 2 lawsuits right now that I filed for Abe. One of them concerns what happened in Maricopa County on Election Day, November 8th, basically the huge lines causing hundreds, if not thousands of people.
In 2022?
This is 2022, to get out of line and be unable to vote, and that was because the ballot-on-demand printers were not tested sufficiently under conditions that you would expect to have on election day. Basically, they printed out when they were doing their stress tests. They sequentially printed out hundreds of ballots using the printers, and they ran those through the tabulators for the test. But we know on election day, any person who is prepping for, let's say, an event, a really good example would be like a fair. You're going to stress test the entrance mechanism, let's say the ticket sales, under conditions that are reasonably expected. But for some reason, Maricopa County decided they were just going to do this based on their own terms. They arbitrarily decided we're going to print out all these ballots sequentially. What that means is that the fusers here and the printers got very hot, and they actually fused the ink to the paper. But on election day, because you print out ballots not in a sequential order, but every 10, 15 minutes someone comes in, you print a ballot.
As needed.
As needed.
Okay.
That's ballot on demand printers. That's what they do. They effectively did not get the fusers hot enough to have the ink fused to the paper, so the tabulators couldn't actually read the ballots. And that caused 3, 4, 5, 6 hour lines at these voting centers in Maricopa County to form. And our contention is, based on the affidavits that we've collected from people that were there on election day, that this resulted in hundreds of people not being able to vote, and that changed the outcome of the election for Abe. That's the first lawsuit.
Now, is that under any kind of a pretense that this was done intentionally, or that it was done neglectfully, or anything along those lines?
So the intent really here doesn't matter. It is really a neglect type standard that we're looking at. Our lawsuits, everything I do is constitutional. I'm a constitutional attorney. That's what I focus on.
Yeah.
And Arizona is very unique. We have, so obviously the 48th state, we're in the capital right now, which is really cool. The old capital from back
the
when
original
we were
capital.
founded here.
That's right.
We had a very progressive constitution. We had the benefit of watching all of these other states adopt their constitutions and pick and choose from those the best provisions to give our citizens the most protections out of really any state, in my opinion. And we have a number of constitutional provisions that are specific to voters in Arizona, the rights of voters. So, for example, we have the right to have the person with the highest number of legal votes elected to office. We have also the right to registration and other laws that are intended to secure the purity of our elections, to guard against abuses of the electoral franchise. We have the right to free and fair elections on an equal basis as citizens, meaning uniform application of our state's laws across the state, not just in Maricopa County, but in Cochise County, here up in Yavapai, all over. And that's really the basis of our lawsuit, is that people in Maricopa County were treated differently than citizens outside of Maricopa County based on the failures of the elected officials in Maricopa County, what they did on election day, and what they did in the way they actually did the mail-in ballot process. And we'll talk about that here in a minute.
Mm-hmm. Right on. And what is considered, what's an example of an abuse of the electoral system?
So an abuse of the electoral system is really what we allege in the Quo Warranto lawsuit, I think is really the best example. In that case, basically what we're talking about is that Maricopa County, instead of conducting signature verification in accordance with what the law requires, the way that Yavapai County does it, the way that Cochise County does it, they deviated from what's called a non-technical law. There's this case out of Yuma County from 1997 that overturned a Board of Supervisors race a year after the election actually happened. Mm-hmm. And in that case, the Court of Appeals Division 1 here in Arizona, they basically explain, when you do not conduct signature verification for absentee ballots in accordance with the law, which is ARS 16550A, that is a non-technical law. It's not just a technicality, because it furthers the constitutional rights of voters. It secures the integrity of the election process. It secures your right to have the highest number of legal votes counted. It furthers our rights to free and fair elections, that are uniform as compared to what happens in other places outside of that county. And so a year after the election, because the county recorder in Yuma did not actually conduct signature verification in the way they were supposed to, they voided all of the results from Yuma County for that race, and they actually changed the outcome. They voided the whole election. And so we're asking Maricopa County in the Quo Warranto action, the court there, to void all of the votes for the Attorney General race from Maricopa County, for the same reasons as what happened in Reyes v. Cumming.
Wow. Okay. Now, what a lot of people I've talked to think and say about these types of litigations or court processes is, if we're disenfranchised as voters, or if the election goes in a way that it shouldn't have gone for whatever reason, and then we pursue this through court, and it takes us years to accomplish any kind of anything or some kind of justice, what's the point if in the meanwhile these same people are essentially committing treason, in my opinion, to destroy our nation during that time?
So the point is that I'm going to win, and Abe Hamedeh is going to be the Attorney General of the state of Arizona, and that's I can explain it in detail. It's going to take a little while to get through the court process, but we're not talking about going through a long trial here. We have all the evidence we need to actually succeed, especially in the quo warranto action. I just filed a consolidated response to that case to 3 motions to dismiss last week. I'm very tuned in to the specific issues there. And if you give me a little bit of time here, I'll explain the law and explain why Abe will be the Attorney General.
Please, but before you do, one quick question about that. Will he become the Attorney General, General for the remainder of time of that position, or will he get extended time because of the 2 years that it took to prove the issue?
So he has the right to assume the seat for the remainder of the term.
The remainder of the term.
He was the lawfully elected Attorney General of the state of Arizona based on the law as it's written and based on the Constitution of our state. And he's actually entitled as well, and we're asking the court to allow us to amend the complaint to seek this. We didn't initially ask for this because we didn't think it was necessary, but based on the filings from the Attorney General in the motions to dismiss and the way that she misled the court, and in my view it was very purposeful, we have asked to seek personal damages against Chris Mays for usurping the office and actually give Abe not only the salary that he's entitled to, but the damages from having to litigate his other cases, the sanctions that have been awarded against him as well. So we're trying to get as much personal liability and justice as we can out of this.
I think that's super important. The more people have their own necks stuck out there, the less likely they are to push the envelope when it comes to screwing over the people.
Yeah, absolutely.
As far as Mark Fincham and Carrie Lake's cases, separate attorneys, right? Do you have any association with those cases, or do you work with those attorneys in any way?
I am not associated with any of the other election lawsuits. I don't work with Carrie's team. I don't work with Mark's team. I'm really on my own when it comes to the election work. It really got into this out of necessity. It's not something that I wanted to do, but I'm glad I'm here.
Me too.
Effectively, what happened was I was working for the nonprofit. I ended up just kind of take a step back here. COVID obviously happened. My wife has a job. She gets paid well enough to take care of my family decently, and so I was blessed to have a near full ride to go to law school, a scholarship, merit-based scholarship. And so I graduated debt-free from law school, which is very rare.
Nice.
And I was very, very blessed. And so when all this happened, we needed to have seed money to fund the nonprofit. It's a 501c3 public charity. And so we actually liquidated one of our family vehicles, and I used that to fly around the state of California the first 3 months of 2022, and I actually ended up teaching kids and their families how to civilly disobey their school's mask mandates. We were setting up Rosa Parks-style lawsuits. That was the whole idea. I sat outside of Tesoro High School in South Orange County for 3 days, and I negotiated between the Orange County Sheriff's Department, the principal, the parents, the teachers, and my client, the student. Basically, the kid was offering to peacefully submit to arrest because he had been quote-unquote suspended for violating the school's mask mandate and was sneaking back into school based on my direction. I was teaching him to go back into class, to politely take off his mask, sit back down, demand an education. And so we have 3 lawsuits right now in California where we had kids that were kicked out of class for multiple weeks at a time, refused to wear masks, and they're actually filing personal lawsuits now against the teachers, the principals, the school board trustees. In the Coronado lawsuit, which is San Diego, we sued more than 20 people on behalf of a young girl that was forced to sit outside for 6 weeks because she didn't want to wear a mask. She had to wear. This girl was, alienated from her friends, humiliated by her teachers, stuck outside in the cold. It was so cold on that island, she had to wear a jacket with a battery-operated mechanism that electronically it heated her
Yeah.
to stay warm, just because she didn't want to wear a mask. They had a lockdown drill one day during this time. And the school's solution for her, for the lockdown drill, was to stick her in a bathroom that didn't have a lock on the door. So she was a fish in a barrel.
So she wasn't locked down.
Yeah,
and
they were
the school
humiliated.
didn't perform their responsibility to keep the child safe in that situation.
Yeah.
Do you know of anybody else that's done that or is doing that?
I don't know of anyone else that's ever done this.
Okay. Whenever you get extra time, please teach people how to do that.
Yeah.
That's extremely important.
There are all sorts of videos on my Instagram page, the Gavel Project, if you want to look at it, where I actually, well, I guess they're not on there. They were on Instagram initially, and then Instagram would take the sound out of my videos.
Of course they would.
And so the best one to watch is the one on my Rumble channel, which I sort of started a podcast, but then I got too busy with litigation. Mm-hmm. I did teach people how to do that, and we have set up a bunch of lawsuits based on that. We also have a lawsuit. We have a trial. This time next month, I'll be in California in federal court on behalf of a young girl that drew a painting that said Black Lives Matter, and then underneath it said All Lives Matter. And her principal, she was in first grade, he forced her to publicly apologize in front of her friends. He told her it was racist and it was inappropriate for her to write that statement. And so we're suing him, we're suing the school, we're going after all these people because they're really harming these kids in the name of ideology.
Yeah, exactly. Yeah, they're twisting their minds in a direction that is not sound, is not logical, is not common sense. Is that guy still working there?
He is still the principal of that school.
Okay.
So.
Wow. All right.
Well, I guess let's get back to what I was kind of going through. So anyway, I was going broke. I worked thousands and thousands of hours pro bono, writing these lawsuits, helping the attorneys, hiring attorneys. My wife and I spent, I don't know how much money of our own, putting this nonprofit together, but we did have quite a few people donate, and we really appreciate all the gifts that we can get. Anyone out there that feels compelled, please go to thegavelproject.com. That is thegavelproject.com. Gifts are tax deductible, and we need your support to be able to help hire these attorneys. I'm not licensed in California, so we have to hire local counsel for all this work, and it is quite expensive. So if you can give, please do so. Anyway, my wife, despite having a wonderful job, we do have 2 kids. Both are under 5 and 2 now. And so we were running out of money, and she basically said, you got to do something. And I ended up working for State Senator Sonny Borelli in an election lawsuit. I got encouraged by another attorney that I know well, very good COVID attorney, recommended that I get into this. And so I did. Basically what happened was we filed that lawsuit up in Mojave County. We decided to voluntarily dismiss that lawsuit because Kerry Lake's attorneys had filed basically a substantially similar lawsuit. The causes of action were almost identical, challenging and particularly the signature verification process that was utilized in Maricopa County for this election. Unfortunately, after we had dropped our lawsuit, or sometime around the same time, the motion to dismiss in Kerry Lake's lawsuit on the signature verification issue was granted. And so I decided that instead of just letting this go, I was going to sue Kerry Lake's judge, and that's what I did.
How? Under what?
So I sued Judge Thompson in the Arizona Supreme Court back in January of 2023 for what's called a writ of mandamus. And
Writ of mandamus.
Writ of mandamus.
What does that mean?
So writ of mandamus is an order from the court that is to compel a government agent or officer to do something they're required to do by law. It's very simple. Like, if you don't abide by this law, we're going to tell you you have to do it. And if you don't do it, we can arrest you. It's very simple. So it's not for damages or anything.
Right.
And I sued him as a pro se litigant, as a voter who was disenfranchised from Maricopa County, based on the fact that Maricopa County did not comply with the non-technical signature verification law, which is ARS 16550A.
And that he when presented with that in court, didn't uphold the law in that case?
No, not necessarily.
Okay.
He was never presented with that case, and that's
Okay.
the problem. Carrie Lake's attorneys very unfortunately missed this binding precedent out of Yuma County. In their research, they didn't cite it. It was cited in Abe Hamedeh's case up in Mojave County. I obviously found it as well, so other attorneys had found this, but for some reason, Carrie's attorneys didn't see it. Didn't cite it, case got tossed out, so I basically said, hey, Supreme Court, here's this situation. Judge Thompson missed binding precedent. I don't know, exactly why that is. Now I kind of have an idea, and it was the attorneys for, Attorney General Mays and for, actually, so she wasn't involved in that case, but Governor Hobbs, the Maricopa County attorneys, they didn't disclose this binding precedent to the court as they're required to do. And so that case was thrown out, that signature verification cause. There was the trial in December, and then I sued Judge Thompson in January saying, hey, Supreme Court, he missed this binding precedent. Can you just make him do it over?
So in his position as a judge or a justice, whatever the technical term is, he's required to know that legal precedent and to operate based off of that case that took place in the past?
So he's required to do, diligent research as well. His clerk is required to do that.
Got it.
I don't know what happened necessarily. I will say what's interesting about Reyes v. Cumming is that basically the case, if you know what LexisNexis is.
I do.
And if you know what Westlaw is, these are research databases. These are what attorneys use as, every single day to do legal research and writing. In LexisNexis, Reyes v. Cumming, the substantive part of the opinion, the actual words of the judge about what happened in that case were not available on LexisNexis. They had been either removed or they were not uploaded. Basically, the whole case, when you looked it up in LexisNexis, just said reversed and remanded with instructions. I found the case using another research database. And in this case, this very important case from Yuma County, same circumstances, what's happening in Maricopa County. I don't want to go all conspiratorial.
We can.
But
I got questions.
yeah, this case overturned a Board of Supervisors race based on the same exact violation of law in Yuma County in 1997, a year after the fact. And that case was not brought to Judge Thompson's attention. Either he missed it or whatever. I know Carrie Lake's attorneys definitely missed it.
Yeah.
And so, my hope by filing this lawsuit against Judge Thompson, I didn't have any ill will against him. I just thought it was a mistake. I still don't have any ill will against him. I still believe it's his mistake, but, honest, was to get the court to simply, instead of have the case proceed through the appellate level, get back sent back down so we could save time and actually have that issue tried so Carrie could prevail. Instead of getting disbarred for suing a judge or getting sanctioned, as I think a lot of people would expect, the Supreme Court asked me to intervene in Carrie Lake's case by filing what's called an amicus curiae brief. And that is simply a case from or a lawsuit, or it's not a lawsuit, it's a brief. It's a third party intervening in the case who has not necessarily an interest in the outcome, but wants to provide perspective to the parties and to the court that aren't being argued. And so I actually ended up, after I sued Judge Thompson, I got hired by a very wealthy individual from Maricopa County to file an amicus brief in the Supreme Court in Carrie Lake's case. And I did, and I won. And I'm the reason that her case got sent back down for a second trial in May on the issue of signature verification. That was my work.
Well done, man.
Thank you.
That's awesome. That's amazing. Thank you for what you're doing. It's super important. What was the end result with that second iteration of that case?
So it's a good thing we have lots of time here because it's a bit complicated. So the case gets sent back down, and the ruling came out, I believe, in late March. There was an issue of sanctions in the Supreme Court to be awarded against Carrie Lake's attorneys, which they actually did award because they lied to the court about and basically claiming that it was undisputed as a matter of fact that Maricopa County inserted 35,000 ballots into the stream on election day without chain of custody documents. That was nonsense. They ended up getting sanctioned, and once sanctions came down in early May, the case got remanded to Judge Thompson for a trial on the issue of signature verification. And so my client, Mr. Mast, asked me to intervene again as amicus curiae, this time in the trial court. And so we wrote a brief. I was working with another attorney out of California at the time. We drafted an amicus motion, an amicus brief, submitted it to the court. we had asked Kerry's attorneys ahead of time for permission to intervene. And at the motion to dismiss hearing in the lower court, this was May 12th, I believe, everyone objected, even Kerry Lake's attorneys, to including my argument. So I don't want to speculate as to why, but it was not included. And
Can you please? Yeah, I mean, for sure, of course, you don't have to, but I mean, I can't think of a reason why they wouldn't include it. Is there any kind of a legal reason that they might not include it?
no, there's no rational reason to not include. It's funny. There's a wonderful judge up here in Yavapai County named Judge Napper, who has a case before him right now that was filed by the Arizona Free Enterprise Club that essentially makes the same exact argument that I was making on the issue of signature verification. I'm still making in Abe's case in the quo warranto action, which is that you, as the county recorder, when you get these absentee ballot affidavits in, before you can tabulate those ballots, you have to do signature verification. And what that means is that upon receipt, this is what the law says, upon receipt of the mail-in affidavit envelope, the county recorder shall compare the signature thereon, meaning the signature on the outside of the envelope, to the signature on the quote-unquote registration record. That's the voter's registration record. And what Judge Napper has found, and what I've been arguing all along, and this shows the merit of what I've been arguing, this is the same argument that Kerry's attorneys objected to, is that registration record means the documents that you sign as a voter when you are registering to vote or re-registering to vote. And in Arizona, when you register to vote, we have a very unique state, I think the only one in the entire country that does this. You have to show proof of citizenship. You have to prove that you are a U.S. citizen at the time you are registering to vote. So what Maricopa County is doing, as opposed to using just signatures from registration-related documents, is they are taking pictures of these mail-in affidavit envelopes when they come in, the signatures on the envelopes. And once they get verified, they are including those pictures, those signatures, in the registration record. But you cannot register to vote when you fill out a mail-in ballot, because you don't have to prove that you are a U.S. citizen when you do that. All that's required is you fill out the ballot, you stick it in the envelope, you sign the envelope, and you mail it in. You don't show your ID, you don't prove you're a citizen, so that by law cannot be a registration record document.
And Maricopa's using it as such.
They used hundreds of thousands of mail-in affidavit signatures from the 2022 primary election in the general election to verify hundreds of thousands of new signatures and then tabulated those votes. That is illegal.
Wow.
It's undisputed. They did that. I've got testimony from their elections directors during Kerry Lake's trial that they said they did this. So Maricopa County is very unique. They have their own software for signature verification process, right? So Yavapai County, Recorder Burchill, I have an affidavit that I actually included in my quo warranto, the response to the motion to dismiss. She filled one out. And she explains that the AVID program that all the other counties use, when you're doing signature verification, you get to look at every single signature, 5 at a time even, from the voter that's been uploaded to the registration record. What Maricopa County does is they have the reviewers sit down in front of the screen, and they only have one signature at a time that pops up to compare to. And to look at any other signatures in the registration record, you have to scroll with your mouse and just go down on the computer screen to look at everything else. But
so it's like looking back and forth between different pictures that are not. So yeah, you got to get rid of one to look at the other, and then remember what it looks like, and then go back to the other one to compare.
Well, you're basically a comparison, right? You're looking at the one that's being that's subject to review for tabulation. You have the old signature, right? And what Maricopa County did, based on the evidence that was presented in Kerry Lake's trial, this is the one thing they did very well at the trial, is they established that hundreds of thousands of ballots in the signature review process in Maricopa County were accepted, meaning compared, in a matter of under 3 seconds. So there was not physical time for them to scroll on their screens and look at anything but the signature right in front of them. And what's really key here, and this is what Ray Valenzuela slipped up in testifying to, he's the co-elections director in Maricopa County. He said that you don't have to scroll to look at these signatures. If we actually use the most recent historical signature that was provided by the voter as that first signature that appears on the screen. And what happened in the primary is they had 750,000 plus signatures that were incorporated into the registration record because that's how many people voted by mail in the August primary. Mm-hmm. And so that means if just even 1% of those people voted again by mail in the November general, then way more than 280 votes, which is the margin of victory in the Attorney General's race, were affected by non-technical violations of law.
Yeah.
And so Abe wins. This is a very simple argument, and I'm really looking forward to actually having this hearing on March 22nd to explain this to the judge.
Right on. That is awesome. And along the lines of having the signature verification in Maricopa County, when they're looking at the screen, taking less than 3 seconds, the actual standard of law, isn't it only it has to have like a 10% match?
So whether the signature matches really is not relevant to the case that we filed. What we're saying is that when you don't conduct signature verification to the appropriate criteria, the lawful criteria, that's an illegal vote when you include that in your canvas. Mm-hmm. When you basically accept it anyway, put it in, use that in the statewide canvas. And so what this case from Yuma County, again, Reyes v. Cumming, holds is that when you have one of these laws, like signature verification law, ARS 16550A, and that law furthers the constitutional rights of voters in Arizona, when you violate that law, you have a non-technical violation. And if you do it enough, that it creates uncertainty in the outcome, meaning more votes were affected than the margin of victory, the whole election must be void and set aside. Mm-hmm. Because we simply don't know how many illegal votes there were that affected the outcome.
Yeah.
And so that's what we're asking. I mean, we know that, Cochise County, for example, their recorder provided an affidavit saying that they use the Avid system, and when they're doing signature verification, as many signatures as are in the record pop up on the screen for their reviewers. There's no way they could have exclusively compared a signature that is being reviewed to illegal criteria, meaning the prior vote by mail affidavit signatures. And that's really the issue here, and that's why we believe so strongly we're going to win.
Those affidavit signatures that are unlawfully injected into that system, are they uploaded to Avid or are they not uploaded to Avid?
Well, it really doesn't matter. I mean, so my understanding is that, so Recorder Burchill provided that affidavit, and she explained that they use affidavit signatures in the registration record. But because they don't exclusively have the same software that does the exclusive comparison, you actually don't have to scroll, you see everything at once. The probability that there was a 1v1 comparison to just that type of signature is really null and void. We know that the Cochise County Recorder does not include those affidavit signatures in the registration record, which is actually the correct interpretation.
Okay, and that's how they're able to determine that they couldn't have had that same issue that Maricopa had. Correct. Is because they don't include that in the comparison.
They don't. And one of the things, just to clarify too, Recorder Burchill didn't even differentiate really when she said affidavit signatures are included. She could very well just be including early in-person affidavit signatures from early voting centers. When you go and fill out an early ballot at a polling place, which is something that happens all over the state, you actually have to show your ID to a poll worker before they hand you the early ballot. And in both early ballots that are cast in person and early ballots that are cast by mail have to be signature verified. You still fill out the ballot, you stick it in an envelope, you sign the outside of the envelope, and then you give that to, you put it in the Dropbox or whatever is there. They have to do signature verification. The only difference is one of the envelopes, the in-person one, is white, and the vote by mail one is green. But because you show an ID, those in-person early affidavit signatures can be incorporated into the registration record as a matter of law because you showed that you were a citizen and you satisfied the requirements of ARS 16-152 and 16-166, which explains that unless you prove that you are a citizen at the time of registering, the county recorder shall reject the application.
Yeah. Okay. So the outcome for that second iteration of the Carrie Lake case that you had a hand in moving back.
Yeah, so she lost.
Yeah, she lost based on what? What was their conclusion?
So instead of making the matter of law argument that Maricopa County did not in fact conduct signature verification using the proper criteria, meaning the registration record signatures, her attorneys argued that they did not, quote unquote, compare the signatures at all. They just did not, in fact, happen because it was they verified 1.3 million ballots. They did so fast. It wasn't possible to do an actual comparison using the criteria that was set forth in the elections procedures manual, meaning you look at the broad strokes of the signature, you look at the narrow strokes of the signature, you decide whether those two are consistent based on a number of steps. But there's nothing in the law itself, ARS 16550A, that explains that comparison is anything more than to the satisfaction of the county recorder, which I knew all along. That's actually what Reyes v. Cummings said, and I didn't understand why they made this argument. It didn't make any sense. But all that's required is a comparison to the satisfaction of the recorder. And in fact, it would be unconstitutional for the judge, I knew this as well, to overrule the determination on any particular ballot as to whether or not a signature comparison happened, because there was a non-delegation issue. Once the legislature delegates the authority to the county recorder to conduct signature verification, the judge has no say on any particular signature as to whether or not comparison was happening, because the county recorder has the final authority as a matter of law on that determination. It was really a nonsensical legal argument.
Okay. And if they had included your statement in that case, they would have realized...
Kerry would be the governor right now.
Yeah, they would have realized that error.
Yeah. Kerry would be the governor right now had they not objected to including the amicus brief. Or it would have been preserved and we could have been litigating this in the Supreme Court right now. And, now they're stuck in the Arizona Court of Appeals Division 2, spinning their wheels, doing nothing. And, luckily I was able to file another lawsuit. I came up with a theory based on the Arizona Constitution. I mean, law here is very strong for voters. This is something no one else has ever tried before. I file novel lawsuits. That's what I do. I'm very creative. I have ADHD, and God bless me with the capacity to think outside of the box and come up with arguments that no one's ever thought of. But he also makes me lose my car keys on a daily basis. So that's a huge issue.
It's a trade-off.
But I was able to file this lawsuit on behalf of my client, David Mast, the person who I filed the amicus brief in Kerry Lake's case for. And also for Tom Crosby. I don't know if you know who Tom Crosby is. He's a Cochise County Board of Supervisor. He's a citizen, obviously, in Cochise County. And because he's a voter down there, and because they conduct signature verification using the proper criteria, and they use numerous signatures at a time for comparison, and he cast his ballot by mail, his vote down there was diluted and not treated uniformly as all other votes in Maricopa County. And by the way, Maricopa County, 66% of the state's voting population is from Maricopa County, meaning any failure in the signature verification process impacts basically all of the statewide election races. Because the question is whether when you remove the votes from Maricopa County, does the outcome change? And for that actually is the case for the governor's race. That's the case for the attorney general's race, and for propositions 308 and 309 that were in the 2022 general election. It's not the case for Mark Fincham. It doesn't change. Unfortunately, he still loses if you take the votes from Maricopa County out. It doesn't change for the Tom Horn's race, for Kim Yee as well. All those are the same, but those particular races, the contested races, are what we actually sued over back in September of this year. And so that case has been fully briefed now, and we have a hearing on March 22nd, as I said earlier.
Right on. Wow, man, that's a lot of stuff. There's so much information, it's hard to track. I watched all the Kerry Lake trials as they were happening, and it's just, it blows my mind how specific the details get on whether or not they throw something out or uphold the law in a certain area. I hear that and I think, okay, well, you printed the wrong size ballot images on different size paper or whatever, whether it was a computer error or not, there was error enough to change the outcome, right? And it seems like there were half a dozen things you could point at that say this changed the outcome or would have changed the outcome.
Yeah, correct. But because of the way the law works, you have to find laws that further the rights of voters under the Arizona Constitution to have a non-technical law. Anytime a law is passed, let's say, that relates to registration, because Arizona has a constitutional provision that says Arizona shall have registration and other laws in order to protect the purity of the electoral process and guard against abuses of, the franchise. And so when you have registration laws like ARS 16550A, which says you compare to the registration record, right? You have to show your ID. That's a non-technical law. And so the chain of custody laws, not really non-technical. The other causes of action that she brought about the 19-inch ballot versus the 20-inch ballot, not really a non-technical law. Those are more discretionary for the county recorder to do what they want to do with respect to the way that the election is run.
Wow. When people have concern about the open border and all these illegal immigrants coming in and potentially voting in elections, what's the reality of that?
So it is a very real concern for the federal election. So there's a case called Gonzalez out of the Ninth Circuit from 2012 that so Arizona passed this voter ID proof of citizenship law, many, many years ago. And this was challenged by a bunch of leftist organizations and brought to the Ninth Circuit. And the Ninth Circuit said, at least for federal elections, because there's nothing specifically in the Constitution that requires that you have to be, prove that you are a citizen when you register to vote, we are going to nullify that law as it relates to federal elections. But for state elections, you don't have the issue of illegal aliens registering to vote because you do, again, have to show you are a citizen of this state in order to vote in the statewide and local elections.
Wow.
But we actually have a separate form that is created for federal-only voters in Arizona that does not require you prove that you are a citizen. All you have to do is to basically check a box saying, I attest that I'm a citizen. And, under penalty of whatever, it's just ridiculous.
That sucks.
It's the Ninth Circuit for you.
Yeah. Damn. All right. Well, let's move into what's going on right now with Abe Hamedeh and this document you sent me. You said you filed this a couple of days ago as a response to them trying to throw out this case.
Yeah, so I filed a consolidated response to 3 motions to dismiss in this case. Let's talk about
those are the right words.
Yeah, let's talk about what a quo warranto action is, because a lot of people don't know, and I have my brief here in front of me, and I'm going to read just a little bit from it so we can actually establish what we're talking about here. Cool. So Arizona is very unique, and we have a private quo warranto statute. It's ARS 12-2043. And what a quo warranto action is, it dates back to the time of King Henry III in England. And basically, quo warranto translated means by what right? That's effectively what the meaning of that quo warranto is in Latin. And it was a way for the king to challenge people who had usurped office underneath his authority, who were, claiming to be a rightful office holder, claiming to exercise some authority of the king underneath him, and they really weren't. And so he would send out his henchmen to file criminal, basically, proceedings against these people to put the burden on those individuals to demonstrate that they actually do have the authority they're claiming to exercise. And this was a common law right of action, changed a little bit throughout the years, through the centuries. But Arizona adopted a quo warranto action in the territorial days prior to becoming a state. It was a statewide quo warranto action, basically, for the Attorney General. This is now codified in ARS 12-2041. The Attorney General, or locally, the county attorney under 12-2042, to bring an action when they have reason to believe that some office holder in their jurisdiction is exercising authority they don't lawfully have the power to exercise. And so Arizona actually further expands the common law writ of quo warranto to provide a private right of action to citizens that's granted by the legislature in ARS 12-2043. And it's when an individual citizen has been deprived of an office which they personally have an interest in. And that's met because Abe actually is the rightful Attorney General in the state of Arizona based on what Maricopa County did. He has the right, a legislative grant of authority, to file a quo warranto action to challenge the authority of the person holding that office, and that's Chris Mays. And so in this case, we actually use this lawsuit as a basis to kick her out of office. That's what we're challenging. We sent her a letter on December 27th. I sent her attorneys a letter basically saying, hey, you know that you're not lawfully elected for the reasons outlined, In the lawsuit that I filed against you back in September, that's the signature verification lawsuit on behalf of Dave Masting and Tom Crosby. And you have 1 day to vacate the office, and if you don't, I'm going to sue you. And she refused. And when you have the Attorney General refuses to vacate the office or to bring an action under her own authority under 12-2041, which is the Attorney General's provision to bring this, she has a duty to do so based on information that she has when she has reason to believe the office is being unlawfully exercised. When she refuses to do so, then the private person here, Abe, has the right by statute to file a lawsuit in his own behalf and to kick her out of office, and that's what we've done. And so what is required to file one of these? I want to talk about that just for a second.
Yeah.
So, again, all you have to do is basically put enough information before the individual, that would be the Attorney General, upon which she could reasonably conclude that the office is being unlawfully exercised. She doesn't have to believe actually that the office is being, or agree with the reasons for it. She just has to have enough information to believe. And once she refuses, you can file a lawsuit under quo warranto, and that's what we've done. And so we talked about what Maricopa County did wrong, but really what we did here is we filed this action, and the Attorney General, we sued Maricopa County, the recorder, Stephen Richer, we sued the County Board of Supervisors, we sued Adrian Fontes as well, the Secretary of State in this lawsuit. And they were served in early January, and they filed motions to dismiss the case, basically saying we don't have a cause of action, and we fully briefed those now. We're just waiting for the replies back from the county to our response to the motion to dismiss. So
now, are you suing Stephen Richer and Adrian Fontes as individuals or as employees of the county?
As government officials in their
As
official
government
capacities.
Okay.
Although, maybe there'll be some more lawsuits against those people individually in the future. I've got some evidence that some of these government officials, and I'm not going to name names or say who, but we're actually censoring individual citizens online and communicating with Twitter, with Facebook, with Instagram, communicating with the cybersecurity and infrastructure, whatever, CISA, I forget the name of it right now, but communicating to have specific individuals silenced online, to have their accounts taken down and actually removed from the platform for quote-unquote mis and disinformation.
Wow.
And so we're going through those files now, and they better pray we don't find anything, because we did get a public records request back, and if we do, we're going to be filing personal lawsuits on behalf of the citizens they targeted.
Excellent. Are you familiar with the work of John Thaler?
I know who he is, and I have a general idea of what he is doing.
Do you know if there is or is not merit to that work?
I don't know whether there's merit to that work. What I will say is that it's interesting for someone like John Thaler, who claims to be a racketeering attorney, a RICO attorney, to have compiled all of this evidence of racketeering, and instead of filing a lawsuit, writing a book about it.
Yeah.
I mean, what he was saying would make a lot more sense to me if he was suing over it instead of just talking about it.
Yeah. There's been no RICO case filed or anything along those
lines.
lines.
If he files something, he can change my mind, and I'd be happy to see it. But for the time being, I don't trust what he's saying to be true, because he's not taking actions that are consistent with what you would do in that situation.
Excellent. Okay. Let's see what else we got here. So, what are the options of the responses that you could get? They could say, no, we're not going to. Break it down for me, Barney style. So, you sent out a lawsuit to those people in Maricopa County, basically saying, hey, you have failed to do your duty based on the information we've provided. Mm-hmm. Therefore, we're going to ask you to remove yourself from office, and if you don't, we're going to sue you for
quo warranto.
Quo warranto. Okay. Basically saying prove that you have the right to hold that office.
Yeah, so we are challenging the strength of the office holder's title, that being Chris Mays' office. We're arguing that because of what Maricopa County did, that it affected the outcome of the election. They violated this non-technical law by comparing to non-registration related documents in sufficient numbers to affect the outcome of the Attorney General's race, which was only decided by 280 votes.
Yeah.
That requires the court to void all of the votes for the attorney general from Maricopa County, 1.3 million or whatever many people voted in that race, void all of those votes. And by the way, I'm a Maricopa County voter. I voted in this race. I'm asking for the court to disenfranchise myself as well, and to declare the victor based on the lawful votes from the remainder of Arizona, because Maricopa County is the only county that decided to exclusively compare signatures to non-registration related documents when including those in the canvas, and it's illegal.
So they did it wrong. They did it unlawfully. Everybody else did it right. So if you base the election results off of everybody that did it right,
Abe wins.
Abe wins. Okay. And then as far as Adrian Fontes and Stephen Richter, how are they included in this lawsuit? What is their part in this?
So one of the alternative requests for relief that we've asked for is for a new election as well. So we obviously understand that what we're asking for is extreme. The remedy we're looking to void, 1 point however many million people in Maricopa County have their votes taken away. Technically, the writ of quo warranto action means you have to show that you're entitled to the office. So that would be the appropriate remedy by law based on the way this law is written. But
for those individuals as well, for Adrian Fontes and Stephen Richter?
To void all the votes, yeah. But because it's such an extreme remedy that we're asking for, we understand that a judge would be hesitant to actually adopt that remedy. And so we're basically saying, court, you're able to use your equitable authority here to craft a remedy that's going to be much more appropriate. And one of those things we could have is a new election. And so that's why those people are named. They're named because if the judge decides to go that route, we're going to need to have a new election, a special election in Maricopa County for the office of Attorney General. And that would be done as soon as practicable. That's what we're asking for.
Okay. So you're not asking Stephen Richter or Adrian Fontes to do the same thing you're asking Chris Mays to do as far as quo warranto.
Yeah, and we're also,
you're just informing them like, hey, we might try and throw out these votes and do a new election.
Well, Adrian Fontes technically is a necessary party. Really, Richer is more of a permissive party based on the requested remedy, the alternative remedy. But Fontes is a necessary party. He has a duty as the Secretary of State to declare the person, this is actually a constitutional provision from the Arizona Constitution, to declare the person elected who received the highest number of legal votes. So that right now has not actually been satisfied, that provision of the Arizona Constitution, because Chris Mays did not receive the highest number of lawful votes in Arizona. So he has a duty to give my client, Abe, a certificate of office and actually provide that to him. So that's not discretionary. He is a necessary party. He has to do that if we prevail.
Wow. Awesome. One other question about Adrian Fontes and John Thaler. One of the things that John Thaler speaks of is the phantom appointees by Adrian Fontes. Are you familiar with this?
No, I'm not familiar with this.
Okay. I was going to ask if you know whether or not it's true, but basically he's saying that there have been 14 false positions appointed by Adrian Fontes that are either real people and real information that don't know that they're using their information to have this position created for them, basically phantom positions. So that's what I was going to ask about. All right, moving along. Let's see. How many lawsuits are currently open right now?
I have my for-profit firm, which is Heath Law.
Oh no, I mean just for Abe. Abe
Oh,
Hamedeh.
so he technically has 3 election-related lawsuits that are before the courts. One of them is not something that I'm working on. That would be Jennifer Wright and Tim Lasota and Alex Colladin and a few other attorneys that are on a team doing his initial election challenge, which is still in the appellate process. But my cases are the Long Lines case, which was filed in November, and then the quo warranto action, which was filed in December. And I'm very confident about the potential of succeeding in these cases. And even if we don't win, just to be clear, we're taking this case to the Supreme Court. Whether we win or the other side wins, this case will be in the Arizona Supreme Court, and they will decide the outcome because both sides are going to appeal. There's no way that this gets left in the Maricopa County Superior Court.
How much faith do you put in judges doing their duty?
I put quite a lot of faith in judges. I think that there's a lot of misconception about the way that judges operate. I know that I've seen a bunch of really silly articles out there about how judges are, getting emails from Mark Elias, and the emails contain the order that ends up getting adopted. That's not. I worked in chambers when I was in law school. I worked for a judge in Virginia Beach. I know how the chamber's process works. So you don't have people emailing you telling you what to do in cases. That would be absolutely absurd.
Is it possible?
Not in my view, no.
I see. And Susanna Pineda is the judge presiding over the case that you're
Correct.
working on now.
Yes.
And what kind of, I guess, what's her position in Maricopa?
So she's a superior court judge.
Okay.
I don't personally have any experiences with her yet, other than filing a few documents like a motion to consolidate, a few stipulations, things like that, requests to change the dates on certain issues. And she seems to be, just and fair in the way that she's handling this case. I don't like to presume anything about judges. Other than, they have a specific job. Their job is to weigh the arguments that are put before them and to rule according to what the best possible outcome is based on the party's arguments.
Okay.
And I think she'll do that.
She doesn't have any kind of known history of seeing these cases and then deciding a certain way.
Not to my knowledge.
That.
I mean, I believe that she was a criminal judge doing a lot of that type of work. And from my conversations with other attorneys in around Arizona, I believe that she's a fair judge. She'll give us a good shake. So I'm looking forward to this.
Excellent. All right.
I will say, when we initially filed the lawsuit, this was back in September, and we had our hearing set for January 29th before David Mast and Tom Crosby, the signature verification, the first case. She gave us a half an hour for oral argument each side. And now that we've fully briefed these issues and we have the quo warranto action, she's actually giving us an hour and a half for each side. So I believe she's taking this very seriously, and she's going to give us a fair shake, at least at the court.
Oh, that's awesome news, man. Thank you. So I guess to answer the question of, what does it matter if these people are destroying our country in the 2 years that it takes to accomplish these trials? If you're going to win, then it does matter, especially if we can throw out votes, base it off of the legal votes, or even have a new election.
Correct.
So it really does matter.
It also sets precedent for the future. I mean,
Yes.
so the quo warranto is really interesting. There have only been about a dozen of these lawsuits filed in the state of Arizona's in Arizona state history. Most of them were through the state quo warranto action, meaning the attorney general filed the quo warranto under 12-2041, or a county attorney filed a quo warranto. To my knowledge, there are less than 5 that have been filed by individuals invoking the private right of quo warranto action. And if we win this, we're going to be setting precedent that we no longer have a 5-day window within which to challenge an election here in Arizona. In my view, the 5-day window, the election contest statute, this is ARS 16-673, which basically says that you as a elector have 5 days to put together a lawsuit after the canvass is done to be able to challenge any election, and anything beyond that is impermissible, and you can't do anything about the outcome. Even if, for example, and this is actually what the other side is arguing, even if they intentionally conceal evidence for 7 months after the fact, and you don't learn about it at the basis of your lawsuit until months after the fact, even though we know now that they used this non-permissible definition of registration record to tabulate votes in Maricopa County. And that would basically, if this law is upheld, this election contest statute, it would negate our rights as citizens to have free and fair elections in Arizona. And that's why I'm so fired up about this. And I believe we are going to win and establish this good law.
Awesome. Was there any other evidence that was concealed intentionally?
So, I would say that the printer issues that were litigated in Carrie Lake's initial trial in December, you watched that. They basically were saying, 19-inch ballots, 20-inch ballots. They didn't really talk about the printers. The McGregor report came out in April, and in my view, this could have been learned much, much quicker, and I believe they were not forthright entirely with the way they conducted that investigation. She obviously didn't speak to OKI Data, which is the printer manufacturer that actually made the printers in question here. So she didn't really conduct a full investigation, and I would say that it wasn't entirely transparent, and that's one of the bases for the other lawsuit as well, is basically we didn't learn about this until April.
She being?
Former Arizona Court Justice McGregor, Ruth McGregor. She was on the Supreme Court here.
And she didn't do a solid enough investigation into that company or those printers?
Into what transpired on Election Day. Yeah, I don't believe that she fully figured out what happened. I mean, even in her report, she concedes that she doesn't know why why these printers were doing the 19-inch ballot thing.
Okay.
And that should be something you can figure out. It's not
Yeah,
that difficult to bring in an expert and find out what happened there. It's
Yeah.
like,
I know half a dozen
do
IT
some coding,
guys
yeah.
that could probably, yeah, exactly. All right. I guess the last thing on election integrity that I can think of right now would be Runbeck and the, I guess, nepotism regarding the family that's partial owners of Runbeck and
The Thomas.
Yeah, the Thomas. I don't know much about them, but I know that Ben Toma is a congressman in Maricopa County, and then one of his family members is partial owner of Runbeck, which is the third party elections service.
Yeah, so it's not precisely that. So they own a corporation that owns Runbeck shares. That's the situation. So they have basically an investment firm, invests in different companies, and that firm bought a bunch of Runbeck stock.
Do you know what investment firm that is?
No, I don't. Black Mountain something.
It's not
but
BlackRock?
don't quote me on that. It's not BlackRock.
Okay.
Don't quote
I
me
didn't
on
think
that.
so. Okay, Black
yeah,
Mountain.
you can look this up. You can look into just, I guess I wouldn't Google it, but DuckDuckGo or whatever. Or,
I wouldn't Google it. Do you know if they're a majority shareholder?
I don't know.
Okay.
I do know people, and I won't say who, that were invested in that company as well, and they didn't know that they purchased Runbeck, and they actually found out after the fact, and they were pretty pissed off about it.
Oh, okay. So they could have absolutely nothing to do with it.
Yeah, but in my view, like, you don't buy Runbeck election services unless you want to have some sort of stake or control.
Right.
It's fishy, and
Yeah,
I'm not
fishy.
saying they did anything wrong. I don't know,
Yeah.
but it is very fishy and interesting.
Smells funny. Yeah. Okay. Anything else you want to add about election integrity or corruption or weirdness going on in Arizona or Maricopa?
I will say, just to throw this out there, there are organizations out there that create apps or software that you can actually report election-related issues to. One of them is Votify Now. We use some of their data for Abe's initial Long Lines lawsuit. And I would encourage people to look at applications like Votify Now, download those, and it doesn't matter, particularly which one, but we need as much reporting as we can possibly get. And I would encourage Votify Now because I've seen the platform. It looks good. Mm-hmm. But you report what happens at specific vote centers. It gets into a central database. You have your phone number in there. You have your email address. And then people like me, attorneys, are able to actually look at the information and find out what's wrong and then file lawsuits to correct the problem after the fact.
And you can base it off of those app reports, even if I could go in and say, hey, this is happening when it never happened.
Well, that's the thing. I have to. My job as an attorney is to investigate the reports and to actually put together, what happened, put together a good faith investigation for the court. I don't just file lawsuits based on reports. I actually have to look into it a little bit. So.
Okay, right on. Good deal. Well, that's all I got about election integrity. We can talk about a little more about the Gavel Project and what your intentions are with that moving forward, or what the parameters are of its use, or whatever.
Yeah. So. Really, the Gavel Project, we're an anti-woke 501c3, and our whole objective is to stop the craziness that's just ruining our society. The way I define wokeness, and I think a lot of people have different definitions, but my view, it's when you are using an ideology that isn't really founded in reason to compel people to take certain actions. And actually, wokeness can be Christian as well. It can be religious in a lot of ways that I'm a believer. And I see a lot of wokeness in the way that the Christian faith operates, especially with respect to the abortion issue, for example. I believe this is wrong to do based on my faith, but I also think that when we're articulating this to other people and we're making laws that surround this issue, we have a duty to explain in reason as to why we're saying what we're saying, as opposed to just basically pointing to a book and saying, this is the way it is because I believe this book says that. That really is wokeness. That is a faith-based argument that really doesn't have reason underlying it. And so when someone is telling you from the other side of this that we need equity, for example, we need to have equal outcomes irrespective of how hard you work as an individual. We're going to take away all of the merit-based system. That's woke as well because it's not underlined by reason. The same is true for the gender ideology craze. You cannot become I can never become a woman.
Yeah.
It's not possible. My chromosomes, every single one of them is stamped in a particular way.
Yeah.
Every single cell of my body. No matter what I do, no matter if I cut off my genitals or if I, put on a dress and lipstick, there's nothing I can do to change my cells to be female cells. And so that as well is a faith-based ideology. That is wokeness. That's what I believe to be wokeness. I will fight that tooth and nail on either side of the spectrum. I don't believe, so there's this really brilliant philosopher that most people have forgotten about. And his name is St. Thomas Aquinas. I don't remember what century he was alive, but it was, Dark Ages or whatever. And this guy said something that was really profound. He said, basically, we should neither prescribe all virtues nor proscribe all vices, even as Christians. It's not our job to tell people what to do. People should be free to make their own decisions, just as the Lord gave us the freedom to sin. We should give our brothers the freedom to sin, but for the harm that they do upon other individuals. That's the harm principle, the libertarian doctrine that I'm a libertarian myself. I'm not a Republican. That really is the way that we should set up our lives. That is the basis for a free society. You get to do whatever you want so long as you do not harm other people. And when you start passing these laws without actually explaining why you're passing the laws, whether it be for your perceived view of righteousness or not, whoever you push that on is going to have a problem with it. And it's not just and it's not fair. I don't want to live in a theocracy. I want to live in a society where my children have the capacity to choose to go to church if they want to, and I hope they do. But it should be a choice all the time, and that's my view.
Excellent. When it comes to the woke stuff getting transformed into law or into, books in libraries or school curriculum and all this type of stuff, I consider this stuff, and I consider the woke ideology, and I think there's no way that this many people can look at this information and think, yeah, this is a good idea. I'm going to go ahead and go for this. What is your opinion on that?
So, when I was flying around California, when I was teaching the kids to protest their school COVID mandates, which is wokeness as well, by the way. That is a woke ideology. It's not based in reason. We knew at the beginning these masks didn't freaking work. We were sticking these face diapers on these kids, telling them to go to school 8 hours a day, breathing in their own spit, the disgusting bacteria in their mouth, their teeth are degrading, they're passing out when they're running on the playground because they're being forced to exercise in these things, which is, by the way, what happened. That is completely void of reason, right? That is something that goes well beyond individual choice and individual liberty to protect your own self and forces an orthodoxy on you from the state. Only one side of the debate prevails here. There is no standing up or disagreeing. In fact, when you stand up and disagree as a student, you get punished for it. You get alienated. You get stuck outside in a cage, which is what happened in Saddleback Valley Unified School District. We have a lawsuit right now where they stuck 3rd, 4th, and 5th graders outside in a cage for 4 weeks.
A cage?
Yeah, a courtyard surrounded by metal bars, completely surrounded. They stuck them out there in the elements. There was no shade. There was no shelter. 4 weeks in January and February. After the reason these kids went out and decided they weren't going to wear masks anymore is because there was an assembly at their school where the school brought in some speaker who had a room full of kids that were in masks, and he took his mask off and started speaking to these kids. The next day, these kids took their masks off and decided they weren't going to do that anymore. And as a result, the school told them they were being punished. And they stuck them in a courtyard outside that was enclosed by metal bars, and they told them they could not get up except to use the bathroom. They had to watch their friends every single day go to recess and go to lunch, and they had to sit there.
And they couldn't because they wouldn't wear a mask.
One of the kids, a really profound thing happened. He came home. He told his mom, now I know what it's like to feel like a zoo animal. And that's why we're filing these lawsuits. That's one of the lawsuits we're sponsoring.
So when you see these principals or these school staff that are enforcing these issues, do you think that those people really agree with the woke issue? Or do you think they're just doing their job to get by? Or do you think like maybe they're being paid to do this or incentivized somehow?
I think it comes down to public shame, and that's really what I was getting to that point. That when I was flying around California, these kids were being told that they are vile and disgusting for taking off their mask by their teachers. They were being publicly humiliated, and put in a position where social ridicule was so extreme that standing up against the grain took a true act of courage to do. I'm lucky. I have a very unique history as a young man. When I was 17 years old, by the time I was 17, I'd blown my left knee out 4 times playing football. I was not the best kid. I wasn't the best behaved kid. I grew up in the principal's office. I was very defiant as a young man. I ended up actually getting sent to a wilderness therapy program. I had to go live in the woods for 2 months.
How was that?
It was the best thing that ever happened to me.
I bet, man. That sounds awesome. I would love to do that.
Yeah, I got to live under a tarp for 2 months in the southeast part of Utah in the summertime. It was beautiful. And then I went to a therapeutic boarding school. I ended up I had my college paid for. My brother and sister got to go to great schools. I had to go to community college for 3 years because I spent all my money on drug rehab for the oxys that I was taking for my left knee.
Oh, wow.
And I was able to overcome that. I paid for school on my own. I went to school 5 years as an undergrad, and I worked full-time. At one point, I had 3 jobs. I was working and going to school full-time. I graduated debt-free, paid for it myself. My wife helped as well. She had a good job and good scholarship. But anyway, getting back to the point here, the public shaming is really the problem here. I think that when you step out of line as a kid today and you basically are told that you are a POS because you happen to disagree with your teacher, and your teacher actually encourages the kids around you to make fun of you and encourages your classmates and your peers to ridicule you, that's what wokeness does. I don't have a problem with that. I don't give a crap what people think about me. I wouldn't be doing what I'm doing today if I cared what people thought about me.
Yeah.
So I hope I can inspire others to adopt that mindset, because that's true freedom.
Yeah.
I stand on my own feet, and I think kids should as well.
Yeah. There's no way there can be that many idiots that look at this information and think, yeah, that's a good idea. Let's do that for the kids. That's got to be another.
Well, that's DEI, right? That's
Yeah.
in the corporate workplace. Now we have all of these different standards that are being adopted by the stock exchanges that say that you have to have a certain get fired today.
Yeah, you're putting their profits in danger, or their ability to get a business loan in danger.
The money, that's the thing. It's not really the profits that you're endangering. It's their capacity to qualify for publicly available funds on these exchanges.
Okay. Wow, man. I'm out of questions, but I could give me 10 more minutes. I'll come up with 30 more questions, but thank you so much for doing this, man. Is there anything else you want to share about the Gavel Project, or anything you're doing, or what we people can do to help uphold the Constitution in these types of situations?
I just want to say, if you can, please consider giving. We really need your support. I've given thousands and thousands of hours to the Gavel Project on these cases pro bono. I don't get paid for this.
Yeah.
There's a reason I have to do election integrity work. It's not because I love doing it, although I do have a lot of fun doing this. It is interesting.
Yeah.
But I'm not taking a paycheck. No one's taking a paycheck from the Gavel Project. We are strictly hiring attorneys, and we are hiring paralegals to help us get these cases across the line for the kids. That's what this is about. It's about protecting your kids and my kids and making a sacrifice today so that our kids can be free tomorrow. And so if you do have resources, I beg you to please go to our website, thegavelproject.com, make a tax-deductible gift. $300 is an hour for an attorney for us to hire, and we have to put in, 30 hours a week sometimes when we're responding to
Yeah.
these motions. That's a lot of money.
Yeah, it is.
So we really need you to please divert your money from the IRS to us and help us kick some butt on behalf of these kids. And
Cool.
follow us too. Social media at the Gavel Project is where you can find us on Instagram, on Twitter as well. Twitter is probably the best place to follow us. It's where we post most often. I'm kind of off Instagram since they basically shadow ban me and it's not
Yeah.
worth my time. And you can also follow me as well personally at Ryan_L_Heath. If you want the updates on all of the election integrity stuff, I'm on Twitter, and that's the best place to find me.
Cool. I'll include all that stuff in the notes.
Thank you.
Thank you so much, Ryan. I appreciate you.
Yeah, thank you.